It covers a lot of. हेलो।
जी जी, प्लीज कंटिन्यू।
जी जी। आ, जी। इसमें बहुत सारी चीज़ें आ जाती हैं, तो हम कोशिश करूंगा मैं एक ओवरव्यू देने की, ज़्यादा डीप किसी चीज़ में जाने का शायद एक लेक्चर में जो है वो मौका नहीं होगा। अगर कोई ख़ास चीज़ पे आप चाहते हैं कि मैं उस पर फोकस करूं तो मैं वो भी कर लूंगा, लेकिन यह है कि जनरली मेरे ख्याल में डीप जाने का वक्त नहीं है इसमें। ऐसे ही है।
जी जी, प्लीज सर।
जी जी।
हमारी कोशिश है, मतलब हमारी कोशिश होगी बेसिक्स भी हम डिस्कस कर लें और थोड़ा सा एक्सपर्ट लेवल का भी हो।
ठीक ठीक है। So, as we know, I mean, Constitution is basically law, but it's called a basic law. General law, which we generally talk about, is PPC or the CPC and that type of other laws. These laws are meant for relations between people and people, between the populace. These are the private laws. But the Constitution deals with the structure of the state, how the state is organized, what is its relationship with the people, how the rights of the people are protected, what is the judicial system, or what is the how the governments are formed, how the what type of government it is, or what type of state it is. So these things are dealt in the Constitution. In our constitution also, you see that there are different criteria to make amendments in a law and how to make an amendment in the constitution. Like in a general law, you can amend it with a simple majority. We'll discuss it later on. But a constitution law, we have to amend it by two-third majority, or different sort of uh, a change. It's more strict. It's more inflexible. It's more difficult to change. So that's the this basic difference between the general law, which we discuss normally in everyday discussions, and the constitution law. In our own context, Pakistan's constitutional development have been, very quite haphazard, of course, but it has a long history. The first at the start of the after the independence, we had to go on with the British given 1935 Constitution, 35 Indian Act, which was adopted as Constitution of Pakistan, and it continued till 56. From 1947 to 1956, we made a lot of efforts to make our own constitution. But there were difficulties because of our peculiar geographical realities, because half of the population was living in then East Pakistan, which was 1,000 kilometers from what is now Pakistan. And there were different states and provinces, and people were, of course, have different languages. So those things created problems for us, the establishment of the making of the constitution. Uh, there were basically, if we see in those 9 years, the basic problem was, of course, the fact that the people of East Pakistan, now that's called Bangladesh, had majority of the population in Pakistan. Their size, geographical size of that area was quite small, but the population-wise, it was more than half of the country. And unfortunately, there were people, or there were powerful groups in this part of Pakistan, which is now Pakistan, especially in Punjab, where people were not sort of mentally prepared to accept the fact that in a democracy, the Bengalis, the people of the East Pakistan, would be more likely to farm the government, or have upper hand in the government. So that created one way or the other, that created problems for the making of the constitution. Via media was found in 1955, and it was agreed that that there was the provinces and states of the West Pakistan will be united in one unit, and that will be called West Pakistan. There were only two provinces in the country, West Pakistan and East Pakistan, and both will have equity. I mean, their parity. Both will have equal number of seats in the National Assembly, and of course the Constitution, the legislature was to be unicameral. So that continued. And on that basis, we made this 1956 Constitution. But still, there was a thought probably in this part of the country that especially in Punjab, that that there will be 50% seats for East Pakistan, and there are 50% seats for West Pakistan, and the people from the political parties from the East Pakistan, with support of political parties from the non-Punjabi areas, probably will be able to form government. So that led to problems, and ultimately it resulted into the imposition of martial law in 1958, and that continued for last another 10 years. And it gave way to another martial law when Ayub Khan, there were protests against Ayub Khan, and then that sorry state of affairs that happened in 1971. And that East Pakistan was lost in the war with India, and that became an independent country. And with that, we arrived with a new Pakistan, what was called New Pakistan, and then New Pakistan. Fortunately, we were able to get a constitution. Despite there were problems between the political parties and the government at that time, but despite that, there were people in the National Assembly and that time, and we had the political parties who can ignore their own differences and agree on a unanimous constitution in 1973. Now, if we look at our 1973 constitution. The basic features of this constitution are from very inception of Pakistan, or even before the independence movement. If we look at the whole struggle for Pakistan, Muslim League had always demanded a federal India, in which the provinces had sort of autonomy, there was provincial autonomy, and these rights of the provinces were secured. And if you revisit Qaid-e-Azam's 14 points of 1928, you would see many points on that in this regard. So Pakistan had to be a federation that was from the inception. So 1973 Constitution conceded that point, and we had a federal structure in which there were the rights of the provinces were enumerated. There were three-wise division in the of powers among the provinces and the federation. There was the federal list, and they had actually two parts at that time. And then there was a concurrent list. In the federal list, of course, the federal government was empowered to federal parliament was empowered to make all the legislation. And then there was the concurrent list. In concurrent list, of course, the provinces were allowed to make laws. But in case of clash, the federal law was had the supremacy. Uh, the remaining subjects were with the provinces. That is a difference between, in fact, Congress and Muslim League during the independence movement, that Muslim League wanted the residuary subjects to go to the provinces, and at that time Congress wanted these residuary powers to remain with the federation, or what in India they call it union. They don't call it federation. Actually, they call it Union of India. But that was the difference at that time. So residuary powers went to the provinces. But even at that time, the leaders from smaller provinces said that too much power has been given to the federation, and more powers should be given to the provinces, and they wanted the concurrent list to go away. And ultimately, as everybody knows, that in 2010, the major political parties conceded that right to the provincial, that right to the provinces, and now the concurrent list is no more in part of the constitution. That was, that federal structure was one important factor. Then the other thing is the parliamentary form of government. From the very inception, even despite the fact that at time of independence, Qazi Muhammad Ali Jinnah, instead of becoming prime minister, he opted to be the governor general of the country, which was a nominal post actually. But despite that, from the inception, there was a conscious decision, and Qazi Azam had given a lot of time in many interviews. Qazi Azam had said that Pakistan will be a parliamentary democracy on the style of the Westminster. We from 1947 to 56, as we know, we tried that form in the country, and then in 1956 constitution also there was the president has a bit more powers, but still it was a parliamentary form of government. Ayub Khan during his tenure actually wanted that he introduced a presidential system. But the people of Pakistan always wanted a parliamentary democracy in Pakistan. So in 1973 Constitution also gave that, conceded that demand of the people. In fact, it is sad when people have written that Zulfikar Ali Bhutto himself wanted their presidential form of government. But there was a general consensus for the parliamentary form of government, and that was accepted. In 1973 Constitution, the original Constitution that was enacted in that time, the president's office was just a nominal. It had nominal power. It just was an honorary post. He had no real powers. Like in the constitution, in the lawmaking, there was the president. It was written that after the passage of any law in both houses of parliament, president will assent in 3 days. If he doesn't assent in 3 days, then that will automatically become law. And in Article 48, again, on the advice of the, if the president, if the prime minister advised president to do anything, and if he doesn't act on his advice within 3 days, that will it will be deemed that the president has assented to that advice. The same way, the prime minister could ask the president under Article 58 to dissolve the National Assembly, and the president had no power to resist that. He just had to. He he had power to wait for 3 days. If he assented in 3 days, that the assembly, if he couldn't assent in 3 days, the assembly will be automatically dissolved. The same way, the prime minister was the commander-in-chief of the Pakistani Armed Forces, and it was the prime minister who advised the president to appoint the provincial governors, and the provincial governors were effectively serving till the pleasure of the prime minister. And the president had no role in that. So the president's office was basically a ceremonial office. It was the prime minister who was head of the government and who had the real power in that. After 1977's military coup, General Ziaulak tried to. I mean, during 1977's movement against Zulfikar Ali Bhutto. There were slogans written outside the presidency. Present day Fatima Jinnah Women University in Rawalpindi used to be the presidency at that time, and there were some people had written slogans on the bars of that presidency. That Fazl Alai Gurhagar, Fazl Alai was the Chaudhry Fazl Alai was the prime president of the country. So there was demand. There was sort of people were talking about the powerlessness of the president. So they have used that sort of slogans to disempower the prime minister during when he restored the constitution in 1987, and the president was given a lot of powers to oversee the parliament and the prime minister. He had, there was a notorious power with the president at that time to dissolve the parliament and thus dismiss the governments, dismiss the prime minister also. After what we called the 58(2)(b). That 58(2)(b) was used by General Ziaulak to in 1988 to dismiss the prime government of Mahmud Ganjanijo. Then in 1990, Benazir Bhutto Sahiba was dismissed under the same law, and then 93 it was used against Nawaz Sharif Sahab, and then in 96 again Benazir Bhutto Sahiba. So it was quite misused. Then Ziaulak also became the commander-in-chief of the armed forces, and he got the power to appoint the services chiefs and the joint chief of chairman, joint chief of staff committee, and he gave himself the power to appoint the provincial governors, and he also could veto the bills passed by the National Assembly or send them back their bill, and that sort of thing. That lot of things were given to the president. The Parliament tried to get some powers back by the 13th Amendment passed in 1997. During that amendment, the 58(2)(b) was deleted, and the power to appoint the provincial governors and the services chiefs and the Chief Justice of Supreme Court were taken back by the Prime Minister. But that proved short-lived, and in 1999 there was another coup, and John Sharaf took over, and he did almost the same things which General Ziaulak had done in 1995, and he amended the constitution at his will. A lot of changes he also made in the constitution, and again after his ouster, the Parliament again in 18th Amendment 2010 restored almost all the powers of the Prime Minister, and we are almost at where we were in 1973 as far as the powers of the Prime Minister are concerned, or the powers of the President are concerned. So the President is now as its ceremonial head, like he was in 1973, or as in a parliamentary form of government, the head of states are in Britain and all other countries, all other countries with the parliamentary democracy. And then this 1973 constitution is quite rich I mean, it is a bit difficult to amend the constitution. It's not as difficult to amend as the United States Constitution is, because in the United States, along with the two-third majorities in the Congress and the Senate, you have to pass it from the legislatures of the to three-fourths of the assemblies of the states. But in Pakistan, like its constitution, every part of the constitution can only be changed by two-third majority of the members, all the members of the National Assembly, and then the two-third majority of the all the members of the Senate. So, if there is a vacant seat in the National Assembly or the Senate, that doesn't actually has any impact. You are we have 36 seats in the National Assembly today, and we have to have, even if there are people are missing, but the two-third majority of the 336 members is needed to pass a constitutional amendment. And the same goes in Senate. That's quite different from what we have in the for any lawmaking. Any ordinary law. For ordinary law, when we pass by simple majority, that is majority of the members sitting and voting. Like a quorum in the National Assembly is of 86 members, and if 86 members are present and half of them actually don't vote, and other wards are voting, and some of them don't support the bill, and the others majority support. For example, like 30 people support that bill will be passed, and that will become law. But that is not this case is not available in case of constitutional amendment. Constitutional amendment can only be passed by two-third majority of all the members of the National Assembly and two-third majority of all the members of the Senate also. There's another difference when there is difference between between the National Assembly. If National Assembly passes a constitutional amendment bill, and that bill is not passed in the same manner by the Senate, then it can't become a law. In case of in ordinary law, if a bill is passed in the National Assembly and the Senate doesn't support it, then it will go to a joint session where with the support of the majority sitting and voting again, that can become a law. But that course is not available in case of the amendment in the Constitution. Amendment in Constitution has to be passed by two-third majority by both the houses. So sometimes the sitting governments have much support of two-third majorities in the National Assembly, and they want to pass an amendment, but they fail to do that because they don't have a majority in the Senate. And we witnessed that sort of thing very very evidently, and there was a lot of problem on that. When in 1997, probably, or 1997, Myanmar was the Prime Minister, and he wanted to make an amendment in the Constitution, and that was when people actually dubbed it that he wanted to become Amirul Mu'minin, and that sort of the amendment was of that sort. But it was passed in the National Assembly, but it was opposed in the Senate, and it never became a law. So that sort of things happen sometimes, and this condition of having sort of two-third majority from the both houses supports the provincial rights also. Again, it's a sort of it strengthens our pattern structure that Punjab or Punjab, despite being the half of the country, cannot pass any amendment, cannot amend the constitution at will. Even two provinces cannot amend constitution at will. they need the support of almost more than three provinces to get it passed. The people from these three provinces. So people, the members from single province cannot amend the constitution. The national, in the case of the law, probably that might happen that with smaller political parties get more share as far as the constitutional amendment is concerned. One issue that has been concerning both Pakistan and India vis-a-vis the constitutional amendment has the theory of the basic structure. That has started in India in 1974 when Mrs. Gandhi imposed emergency in that country because of that problem with the judiciary. And that has emerged in Pakistan also in from 1990s onward. And in Asfandiar Valley case, Supreme Court had decided that there is a basic structure of the constitution of Pakistan. But like it's a judicial, it's a parliamentary character, it's Islamic character, it's patriot character, and that sort of thing. That he said that these are the pillars of the constitution, and the parliament cannot amend this basic structure of the constitution. So that has more or less been followed one way or the other. But that is, in India also it has been criticized a lot because in the Constitution, if you read Article 238 and 239 of the Constitution, there is no bar on Parliament to amend the Constitution. The Parliament can make any change with the two-thirds, with the required majority in the Constitution, which it likes, except there's one exception only. The Parliament cannot change the boundaries of the provinces. The Parliament cannot change the boundaries of the provinces without the consent of the Provincial Assembly. Any change in the boundary of the provinces has to be agreed upon by the majority of the members of the Provincial Assembly concerned. So, except that exception, the Parliament under the Constitution can make any amendment in the Constitution.
Sir,
But
sir, apologies to interrupt. We have
sorry?
approximately 5 minutes left, and if you can take the questions as well.
Yeah,
And
it's okay. Oh, I thought, I couldn't see the time because we lost a lot of time earlier while, in
apologies,
technical
there
issues.
जूम का बेसिकली ये है कि मैक्सिमम हमारे पास 40 मिनट्स होते हैं. यूट्यूब पे अगर हम कंटिन्यू करें तो हमारे पास लाइक 1 आवर होता है. तो इस पे
अच्छा.
काइंडली इफ यू कैन रीड आउट 2 क्वेश्चंस आर देयर, इफ यू कैन आंसर प्लीज.
It's on permission access to camera. No. It's on WhatsApp.
Sir, let me read it
Hello.
out. Yeah, let me read
Yeah.
it out for you. The first question is from Chani Jamali. What Constitution says about this situation? For example, current scenario of Nepal, where violence is defended behind the shield of regime and change and inqilab.
I mean, what Constitution can say on that? I mean, they in Nepal, the things have imploded actually, and they have the government has collapsed because of the continued protests in the streets. Same happened in Bangladesh last year, and previously that happened in Sri Lanka also. But Constitution doesn't say things on that sort of thing. But the point is that I don't know in what way the what happened in Sri Lanka or in Bangladesh in Nepal will promote democracy in those countries. Because as we have seen in Bangladesh, the government has been virtually been taken over by army, and same seems to be happening in Nepal also. And it happened almost, I mean, if you go through the same way in Sri Lanka too. And I mean, it doesn't per se, that promotes constitutionalism in any of those countries. But let's hope things normalize there also. And other question, please.
Sure, please. Sir, there is a second question. So it's by Muhammad Baksh Meskanzai. Could the 26th Amendment be in conflict with the basic structure doctrine, even though Pakistan does not formally recognize it in all jurisprudence, especially in relation to separations of power or the independence of the judiciary?
Actually, again, what I touched that basic structure theory. I mean, to me, frankly, there is no basic structure as such. It doesn't. The Constitution doesn't recognize it. Of course, the Supreme Court has said that there is a basic structure where independence of the judiciary and the Islamic character and the this parliamentary democracy and federal structure also Islamic provisions. But the parliament is supreme. The in the preamble of the Constitution says that the Pakistan will be governed by the chosen representatives of the people of Pakistan. So it doesn't say anything about the judges or any other people. So they can make any amendment in the Constitution per se. But even otherwise, the 26th Amendment, how is it in violation of that basic structure? What 26th Amendment has changed, they have changed the procedure of the appointment of judges of the higher judiciary. And that is, I mean, that is not something that has changed the character of the judicial structure of the separation of power. The judiciary and there's a checks and balance. I mean, when we say about this separation of power, at the same time there's checks and balances. The legislature, the executive, and the judiciary, they have independence, but they have dependence. At the same time, one can have powers over the other, and the others have power over on itself. What had happened over the years in case of judiciary, it was that the judiciary had become sort of an independent of the legislature and the executive, and it had got control over the legislature and the executive, and it had given itself powers to dissolve both the to host the members of the national parliament and host the